I look forward to implementing the various recommendations she made, because what happened over the past year shouldn't have happened. I take responsibility for it. We need to make sure that my government or any government going forward never is in that situation again.
Prime Minister Justin Trudeau is not apologizing after the Ethics Commissioner ruled yesterday he broke the rules when he tried to pressure his Attorney General into helping SNC-Lavalin avoid a criminal trial. That Attorney General was Jody Wilson-Raybould. She was also Trudeau's Minister of Justice, making her a top member of his cabinet. So when this controversy broke earlier in the year, Trudeau asked former Attorney General and Deputy Prime Minister Anne McLellan to investigate whether those roles should be split. Yesterday, she released her opinion. Well, actually, the Prime Minister's office released the opinion saying, "I do not believe that further structural change is required in Canada to protect prosecutorial independence and promote public confidence in the criminal justice system." McLellan did make a number of recommendations, though, that she says could prevent a repeat of this affair. And Anne McLellan joins me now from Edmonton. Hi, Ms. McLellan. Great to see you.
Hi, how are you?
I'm great. I appreciate you making time for us. I wanted to start off by asking you just about the sort of very basic conclusion you reached. I know there's a lot of pages in this report and a lot of study that you did, but
yes,
at the end you decided that the roles of Attorney General and Justice Minister should not be split. Why?
Well, I think if you are looking in the context of criminal prosecutions, where in fact the most concern lies in relation to the possible political interference with criminal prosecutions. If that's your problem, by splitting the roles, if you split the role of Attorney General as it relates to criminal prosecutions, if that person is still a cabinet minister or still an elected official, even though not a full cabinet minister but called to cabinet to provide legal advice, that person is still going to be subject to the potential of political influence or interference. So splitting the two roles, as long as that person is still an elected official, doesn't get you where you want to go. It doesn't deal with the problem of the perception of possible political interference. So the only other solution that the world seems to have come up with is that you have your Attorney General in the context of criminal prosecutions, not an elected official. You could look to the Israeli model as an example of that. But that, of course, completely ignores these two fundamental principles that are so important: prosecutorial independence and political accountability. And if you take this person out and they are a public servant, you lose the political accountability part here. And of course, having someone as Attorney General who is not an elected official is also foreign to the British parliamentary tradition. In New Zealand, Australia, the UK, ourselves, the Attorney General, whether in or out of cabinet, is an elected official because we value so highly political accountability. You stand in your place as Attorney General and you take responsibility for prosecutorial decisions. You stand on the floor of the House of Commons and you take political accountability for those decisions. No public servant is in a position to do that. And I would point out to people that the Israeli model, where the AG is, for all intents and purposes, a public servant, that model is coming under increasing criticism in Israel because it's viewed as anti-democratic.
So you ruled out that model. You also ruled out splitting the positions altogether. Let me ask you, you did come up with a list of recommendations, though, to further delineate between the two roles. And I want to ask you about one specifically, because you recommended that the Attorney General, quote, be encouraged to explain themselves if they do decide to intervene in a criminal prosecution, for example, or in cases where they don't, in cases which raise, quote unquote, significant public interest. What would determine, or who would determine, what constitutes significant public interest?
Well, I think the Attorney General actually would determine significant public interest. I think if one is looking at a situation where an Attorney General is looking at intervening in relation to a specific criminal prosecution, the public interest, as I say in the report, is context specific. So you have to look at the context of the situation. So is it a matter of interpretation of international treaties? Is it a matter of domestic or international terrorism? Is it, you know, a regular criminal prosecution of some sort? The public interest must be context specific. But at the end of the day, if the Attorney General were of a mind to look at whether he or she would intervene in a specific prosecution on the basis of the public interest, that person, as we outline in the report, should in most cases be willing to entertain consultation with colleagues, take on board the viewpoints of colleagues in other departments who might have views on the public interest, because it's very rare that in complex criminal cases that only one federal government department might be involved. So as we outline, ultimately the determination of the public interest and whether the AG would intervene is up to the Attorney General alone. We outline a process by which we believe the Attorney General can come to a fully informed decision around what is in the best interests of the public interest.
So you know that everybody's listening to these conclusions with the current case that instigated this whole thing in mind. And I'm just wondering if this means, for example, that you believe Jody Wilson-Raybould should have, as Attorney General, entertained discussions from the Prime Minister and other people in his office where, for example, the idea of the potential loss of jobs is concerned.
I can't comment on SNC-Lavalin. That was not part of my mandate. My recommendations are all forward-looking into the future. I think there are clearly learnings from the SNC-Lavalin situation that everybody can take on board. And I would say that in relation to any hypothetical situation going forward, if an Attorney General, if he or she is of a mind to intervene in some way in that prosecution and direct the prosecution, take over the prosecution, it is important to ensure that you have fully informed yourself as to all the dimensions of that situation. But it is the Attorney General's decision and decision alone. She cannot be harassed or pressured by her colleagues or his colleagues. It is up to them, once this process, which I hope is put in place that we recommend, it is up to the Attorney General to decide whether they need to hear from their colleagues. If so, the form of those representations, we recommend that preferably they would be in writing and minuted so there is a transparent public record. But at the end of the day, that process of determining whether there will be a directive and intervention must remain in the hands of the Attorney General and the Attorney General alone.
I just want to be clear, though. Do you think then that the Attorney General, if they make a decision if they are not of the mind to intervene, do they have to entertain that consultation? Is that decision their own?
The decision whether to intervene or not is always the exclusive decision of the Attorney General, and it is their personal decision. They cannot transfer political accountability for that decision to their cabinet colleagues. It is their decision and their decision alone.
Do they have to explain themselves, though? Because what you're saying in this recommendation is that there is to be encouraged to explain their reasons when issuing or not.
Right, and well, yes, and in fact, if one does choose to intervene in the name of the public interest, and Vashi, people need to understand this has never happened at the federal level,
it has not.
right?
That was pointed
and
out,
it has only happened 5 times in all of Canada at provincial jurisdictions. And we do make a recommendation that we think it would help with the public confidence in the administration of criminal justice if attorneys general or also prosecutors felt more comfortable sharing with the public the reasons for some of their decisions. Now, you also have to take on board that if in fact the intervention is in relation to proceeding with a prosecution, you have to be very careful that anything you say in relation to explaining that intervention to the public does not in any way undermine the integrity of the criminal prosecution. But I will give you one example where I do believe more could have been said by the prosecutor, not the Attorney General, but the prosecutor, and that is in relation to the Mark Norman case, where a decision was made not to prosecute. It is actually easier to say more when your decision is not to prosecute, because you don't have to worry about the undermining of the integrity of the criminal prosecution. And I do think that it's my personal opinion, we do not address this in the report, but if people want a concrete example, I do believe that in the Mark Norman case, it would have been beneficial for the Director of Public Prosecution or her prosecutor to be able to say a little bit more to the Canadian public about what happened there. And
what would it be beneficial? Like, do you think it would have been appropriate to hear the reasons for not proceeding with that?
Well, I would leave that up to others, but I think that when you choose not to prosecute, you have greater room in which to move in terms of explaining why.
And that was Anne McLellan in Edmonton. Hi, I'm Vashi Capellos, host of Power in Politics. See more of our show by subscribing to the CBC News channel or click the link for another video. Thanks for watching.